Thank you everyone for your patience while we dealt with that. So good morning or I guess good afternoon now. Welcome to the webinar we're hosting today. So my name is Ivanna Iwasykiw. I'm a lawyer here at Jellinek, Ellis, Gluckstein Lawyers. And today I'm going to be hosting a webinar entitled Challenges Faced by Survivors of Sexual Assault in Coming Forward in a Digital Age. So I think it comes as no surprise to know that survivors of sexual violence, including childhood sexual abuse and adult sexual assault, face very unique challenges. So credibility, memory, and belief issues. This one is a highlight and a huge issue. A lot of survivors are afraid to come forward, frankly, because they're afraid that their memory of the event that occurred or the abuse that occurred is going to be challenged. They're also scared sometimes to come forward because they believe that an imperfect or an incomplete memory can cause them to be disbelieved or be perceived or seen as, liars or attention seekers. And of course, belief, which is a concern that if you come forward as a survivor, somebody will call you and say to you, you're just making this up, you just want attention, despite other credible things that you have said to come forward. Another one is the fear of being sued for defamation or slander. This is something I hear especially between my clients, especially clients who have been sexually assaulted as adults and are intending to go after somebody who may be sometimes high profile or somebody that's well known in a community. Re-traumatization during legal proceedings. This is, of course, a very serious issue because it's known that our legal proceedings are what we call adversarial proceedings. And we call them adversarial proceedings because in effect, it's two sides, each presenting their own case to a judge and hoping that the judge believes their version of events. And we call this adversarial because they're effectively in a contest to try to get the judge or another decider of justice to believe their version of events. And of course, there are unique challenges now in a digital age, such as internet harassment, loss of anonymity, and of course, trial by media. How do we deal with these challenges as lawyers? There are tools that are available. I'd like to share a story with you about a case that I went through recently with a client of mine. In order to protect their identity, I won't be referring to them by their name, of course, or by their gender. This person came to me and alleged that they had been abused by somebody in a high-profile situation. High profile being a person of known repute in a certain and large community. My client came to me because they intended to come forward to say this had happened to them so that it wouldn't happen again to somebody else. And they effectively wanted to hold this person to account to make sure that they weren't making abuse of their power. But they were afraid, and rightly so. They were worried that if they came forward, there would be not only lashback on them specifically or backlash on them specifically, but that they would also be disbelieved, that the person wouldn't actually be held to account, that the organization would attempt to protect this person, or worse, that if they came forward, this case would follow them for the rest of their life. My client, however, felt that it was their duty to come forward, and so they did, to their credit, and a brave choice that was. And my client, despite their best efforts, some of their worst fears came true. They did begin to be harassed online. Somebody found out what their identity was, and they tried to publish that identity repeatedly on social media. My client lived through that, knowing that they were still doing the right thing, but it was hard. We didn't despair though, because as I told my client, there are tools available. There are things they can do to make sure that their anonymity, their privacy, and their safety are protected. And so we carried out the tools that I know are available to make sure that their anonymity was protected. In the end, the social media posts were all taken down. The individual that I say allegedly because they're still ongoing, carried out the abuse, was held to account in certain ways and continues to be held to account. The institution did right by my client eventually, and my client now gets to live a life where this isn't the only thing that follows them around. And I'd like to share with you today that these are some of the tools that we used in this case and tools that we can use in the case of other survivors to ensure that they too can come forward and deal with the challenges that are unique to survivors in a digital age and coming forward. So first and most importantly, a lot of my clients come to me and they say, I have an incomplete memory of the event. I don't have a good timeline. I can't really recall specifically what happened or the name of an individual who may have also been present, the last name of the abuser, all these details. that's not only not unusual, but quite common. And I say to my clients, and I say to you the same thing. There is a difference between mistakes and things that interfere with your ability to be a credible witness on your own behalf, which is what the law needs in order to assist you in getting justice, and memory issues. When somebody experiences sexual violence, whether that's a violent sexual experience as an adult or sexual abuse as a child or anything in between, it is common for that person to develop PTSD as a result. As a result of developing PTSD, structures in your brain are changed. And as a result of going through a traumatic event, the memory of that event is also recorded differently than any other memory is recorded. These two things together can make it difficult for survivors to have a linear memory of either the event or events that happen afterwards. And sometimes it can affect memories of things that had happened in the past and things that continue to happen in the future. But I say, and I say again, loss of memory does not mean a loss of credibility. There are lots of ways to get past this. For example, in my own practice as a civil lawyer, assisting survivors in seeking justice through the civil system, I prepare my clients. So what I do is I sit down with them and I say, let's go through your story. Let's go through what happened to you. And I go through it with them carefully. And then I say, okay, let's go back. So you said that this event happened at this time. Were you living in a certain place at this time? Were you attending a certain school? Were you working a certain job? Were you in a certain relationship? And using these exterior markers, we're able to piece together that timeline that's necessary to support credibility. Careful and considered prep is one of the major advantages you have when you have someone assist you through the legal system. And so this is speaking for myself, but I know that in a criminal practice and in other administrative judicial type proceedings, and I'll explain those in a second, the same kind of preparation can occur to make sure that you're prepared, you're ready, and a survivor is presented as credible with a good memory. So to touch on the administrative proceedings, there are ways that a survivor can report to things such as teachers' colleges, nurses' colleges, college of chiropractors, physiotherapists, psychotherapists, so on and so forth, that results in a quasi-criminal disciplinary type proceeding against an abuser, if that's the individual that abused or assaulted you. So in all of these proceedings, it's a quasi or actual legal process. In all of these proceedings, you may be required to give testimony. And in all of these proceedings, a loss of memory does not mean a loss of credibility, provided that you are prepared correctly. Giving an answer that says, I don't remember, or I can't remember exactly what happened, doesn't have to be a death sentence to your ability to access justice. This is another common issue that I get. So clients come to me and they say, I want to come forward, but I'm scared that I'm going to be sued. I have three big tools available to you to say, you don't need to be worried about this. They're up here on the screen. The first and most important one is statements made to police, courts, lawyers, paramedics, other legal and healthcare providers are protected by the law of privilege. This is a specific kind of privilege called qualified immunity. Effectively, what it means is if you are reporting that something has occurred to you, whether it be violence, long-term abuse, historic abuse, anything along those lines, if you are reporting it to somebody because you are trying to seek help, or if you're reporting it in a legal proceeding, you don't need to be concerned that you're going to be successfully sued about this. Now, I say successfully because individuals are permitted to start lawsuits. I'll be clear about that. But chances are very good that it will go away very quickly because at the end of the day, they may be able to start it, but it's not going to go anywhere. Then the next step is even if they try to start these lawsuits, right at the outset, before they're even able to proceed even past the first step, even leave the gate, there are these things called anti-SLAPP motions. Anti-SLAPP is an acronym. It stands for Strategic Lawsuits Against Public Participation. If you can prove that somebody is suing you because they would like to prevent you from speaking out against, for example, a person in position of power, a person that's abusing that position of power, or a person that's about to get into a position of power, you are considered doing technically a kind of public service by saying to the world, this is something that has happened to me. This person's character, where it's of concern, is something that needs to be considered. And I would like to say something about that. These anti-SLAPP motions, what they do is they let you go to a person who has started a lawsuit and say, you can't proceed with this lawsuit if the whole reason you're doing this lawsuit is because you want to stop me from speaking to the public about something that's important. Because the courts value and the law values ensuring public participation, public knowledge, public awareness about issues that are important to the public, more often than not, my experience has told me that courts will decide that lawsuits that are slap, so to speak, lawsuits are not permitted to proceed. Now, of course, I can't be giving legal advice today, so I can't say that a specific lawsuit that's happening right now might be removed through an anti-slap motion, but this is a tool that's available, and a good tool at that. And most importantly, even if the lawsuit can proceed, even if they get past this, at the end of the day, the person advancing a lawsuit against a survivor has to prove that what the survivor said was false. I've emphasized here, I wrote it out because it's very important. If they can't prove that what you said was false, they can't succeed on their lawsuit. It's not simply that they have to say, you can't prove that what happened is true. It's the opposite. They have to prove that you told a lie, you said something false. So the burden is heavy on them. And frankly, if you're worried that you can't prove that what happened is true, imagine them trying to prove something that went on only inside your own head. If they want to prove that your intention was that you're out to get them, trust me when I say it's hard to prove. These are great tools that are available to you, and I want to make sure that survivors and people who support survivors know this isn't a real or credible threat. So this slide is short, but this slide is important. Re-traumatization in the process. Clients come to me and they say, I'm scared to face this. Not because I need to come forward, not because I don't want justice, but I'm scared of what it will do to me. And that's completely valid. This is one of the worst things that can happen to an individual experiencing any kind of sexual trauma, sexual violence, sexual abuse. It's scary to think about having to not only talk about that, but be questioned about it. And it's a heavy choice to make, and my clients don't make it lightly. I want to reassure survivors that there are options that are available to them to help them. So the Victim Witness Assistance Program is something that the criminal courts offer to individuals who have come forward to make criminal complaints. What it does is it assigns a support person to you. The support person assists you in communicating with the Crown, assists you and supports you as you go through the criminal process, and assists you even up to the point of giving testimony and afterwards. I've had an opportunity to speak with at least one Victim Witness Assistance Program worker, and I can tell you these individuals are committed and dedicated to ensuring that survivors experience the least amount of re-traumatization as they go through the criminal process. This is an important program as well because it offers additional supports for individuals who have come forward to the criminal courts about this kind of crime that has occurred. The Victim Quick Witness Assistance Program is a program you can access through Victim Witness Assistance that allows some funding for therapy to be provided to the survivor. Now, a survivor requires typically a much more substantial amount of therapeutic intervention than the program can provide, but having a little bit, even to get started, can make a huge difference in making sure that a survivor is capable of going through the criminal process with the least amount of re-traumatization possible. It helps with grounding techniques, it helps with tools for managing large emotions, and it helps with things like flashbacks and nightmares. And my clients have spoken well about even having this small amount of intervention. Now, I can't understate the importance of prep. So I gave an example at the first slide about credibility and memory, about how I'll help a survivor go through the timeline of history, the timeline of their events, and make sure that they're prepared to answer questions about what happened in what place at what time. Prep is a key part of ensuring that re-traumatization is minimized, because as we go through the prep process, at least for me, and I know for my colleagues as well, we go through and we check with you. How are you feeling about this? Is this something you can talk about? How can we best approach this? Do we need to take breaks? And more importantly, we prepare you to understand what it is that you'll be required to do when you're giving testimony, specifically how questions will be asked and if and when you need to answer certain questions. We want to make sure that you feel protected and like you have control over the situation. Because even though you have to go through this process that we've decided is what we call the judicial process, in order to get this justice, at the end of the day, the process, especially the one that we take you through, is up to you. The criminal process, you have a little bit less control. You're considered a witness rather than a participant, but you still have some level of control. In your prep with your Crown attorney, your prosecutor, you'll be able to say, for example, I need a support person in the room. I need to do it behind a screen. I need to give testimony behind a screen. I need to give testimony through a television camera. I need to have a witness program worker with me. I need to take breaks. This allows you to create that space necessary to ensure that you're not re-traumatized as you go through the process. And lastly, trauma-informed testimony options. This follows right from that prep that I was just describing. Trauma-informed testimony options are options that have been available for a while, but are now being recognized as necessary, not only for ensuring that you can give testimony comfortably, but ensuring that testimony can be given in a way that a judge actually finds useful and helpful, or any other decision maker. This is because people who have gone through sexual violence, sexual abuse, we know, like I've said, they're more likely than not to come out of that with PTSD. And if PTSD flares up, it can become impossible to give coherent answers, which is not a survivor's fault. The law is beginning to recognize that if you have these mental health issues, there are ways that answers can be given or testimony can be given to ensure that you as a survivor are able to give the best testimony you can, and that your ability to give testimony isn't compromised by having a PTSD flare-up. So there are lots of options, even right now in the process, as it is, to help minimize the re-traumatization necessary. Now, so going back to my story, when my client came forward, they started experiencing internet harassment. The internet harassment took the form of multiple social media posts across multiple social media platforms. Not an ideal situation, of course, but we have tools available to ensure that that stopped as soon as we were able to make it stop. The first and best relief that we're able to seek is what's called an injunction. An injunction is a legal order from a court that something stops. Some post has to come down. Some individual has to stop posting. If that individual isn't responding, the social medias now have the responsibility to make sure the posts don't go up, or they take down accounts. They take down reviews, comments, replies. Injunctions can be extremely powerful tools. And in my experience, where the posts that we're seeking to have brought down relate to a matter that's before the court, and especially relate to matters of somebody's sexual dignity, a court is likely to err on the side of the survivor to make sure that the survivor's dignity is protected. So I've had great success in using injunctions to make sure that any internet harassment that's ongoing is stopped as much as possible. I don't want to understate the value of direct social media reports as well. So this is reporting, for example, to Twitter, to Facebook, to Reddit, to YouTube, to whoever else, directly to say, I've been harassed. My experience tells me that social media companies are beginning to recognize that posts that are made specifically to harass or out or criticize directly survivors of sexual violence, they're less sympathetic and they're less likely to promote those posts. And in fact, my experience has been, if those posts are meant to harm somebody rather than meant to participate in a public debate, the social media companies are more likely to listen to a request to have them taken down. My client did have success, in fact, with YouTube. YouTube was quite responsive to the idea that the kinds of messages that were being put out on YouTube were hurtful to my client, both her safety and her mental health. And YouTube, in fact, responded before an injunction was necessary to take down these posts. I believe it was the same with Twitter when there were tweets. Twitter responded fairly well to at least hiding the tweets, so that making sure that my client's identity was protected and that the other issues that were being raised were outside of that. Lawsuits. I don't want to understate the value that a lawsuit has. A lawsuit against a harasser can also be a separate and powerful tool. If a harasser understands that they can be liable in law for damaging a survivor, and more importantly, paying compensation to a survivor for causing them further harm, distress, or worse, intentionally intending them to come to mental suffering, harassers are less likely to want to keep going with this campaign. My experience with the other case here, the harasser and I actually started a direct correspondence at one point. Somehow they got my contact information, fine. And I explained to them, you will be sued and you will be held to account. Whether or not they listened, the fact remains they eventually stopped. I've had experiences in other cases where a harasser, a poster, somebody that's making these allegations, they receive one contact from me and all of a sudden they're gone. It can be enough to simply say to harasser, you're about to have to pay this person a lot of money. And chances are good, really good, that they'll go away. And lastly, I've added here, sunshine is the best antiseptic. What I mean by that is a lot of people try to hide behind anonymous accounts. Internet harassers think they can act with impunity if their actual identity is protected. One of the things we actually had the biggest challenge with in this case was dealing with anonymous posts by an anonymous harasser. That anonymous poster thought they were protected by making these false accounts. But we were able to contact the social media companies and we were able to say to them, you need to understand this is a threat to a survivor's safety, integrity, and their privacy, all of which they have a right to. And the social media companies said, provided you get us a court order, which we did fairly quickly, we will provide you with the contact information used to create these anonymous accounts. And we were able to use that to locate the harasser. Once that person has lost the ability to try to act anonymously with impunity, the individual has, now their personal life is on the line, they're less likely to keep going with that. And this case that I'm talking about is a fairly extreme case. In the vast majority of the cases we've had, clients don't have to suffer this sort of internet harassment. In the vast majority of cases that we have, clients in fact are able to protect their anonymity right out the gate, which leads me to my next point. There are many legal tools also available to survivors to ensure that their anonymity is protected. I'll go through them one by one, as there are a variety of orders here. So the first option that we sometimes look at is what's called an initialization order. An initialization order says that if you need to proceed with any sort of, quote, public legal proceeding, instead of proceeding in your own name, which is the rule that's typically required, you're allowed to proceed by initials. What this means is instead of the style of cause saying, Ivanna Iwasykiw versus the harasser or the perp, it will say I, or I could choose random initials. It could say KJ. Proceeding under an initialization order obviously protects your identity because it makes it so that in this digital age, people can't just search you up and see what it is that you've done or had done or experienced. Initialization orders are, in our experience, straightforward enough to get in cases where sexual dignity is again at issue. The court understands that this is one of the most vital, personal, and private things that an individual has, and so errs on the side of protecting it. Proceeding as DOE is a lesser but equally important alternative to an initialization order. Proceeding as DOE means that you are able to proceed through the lawsuit instead of under initials as a Jane Doe or John Doe. This gives you total anonymity. You effectively get lost in a sea of other Jane Does and John Does. It can be harder to get a Doe a Doe order or approval from the court to proceed by Doe. But again, in cases where your sexual dignity is the thing that's at issue, the court recognizes that an individual has a right to protect their privacy. And the court recognizes that an individual's sexual dignity is one of the most important things they need to protect. A publication ban and a sealing order are variations of different other options that are available. Publication bans are orders that ensure that media, other individuals, and the courts are prevented from publishing anything that may identify a complainant in a legal proceeding. Now, publication bans can occur both in civil proceedings and in criminal proceedings in different ways. Briefly, in criminal proceedings, a publication ban almost always occurs where the victim of the crime is either somebody who was a youth at the time the crime occurred, or if it relates to sexual violence. Publication bans in criminal proceedings ensure that even though any sort of proceeding may be considered public, the media is prevented from publishing anything that would tend to identify the complainant. This doesn't just mean your name. This also means location, employment information, children, parents, anything that could tend to lead anybody to figure out who you are. A sealing order is a step above a publication ban. A sealing order means any documents, any information, any facts, anything filed with the court, which typically would be considered a public document, is now no longer able to be accessed by the general public. Courts don't as often provide sealing orders, but where there are especially delicate issues, for example, again, violence against a child, especially sexual violence against a child, our experience has been that a court can grant a sealing order, especially if the individual wants to have their life protected and insulated from the things that happened to them before. A sealing order can be an especially powerful tool, along with a publication ban. They're often done hand in hand, to ensure that if a survivor comes forward, especially to speak out against a large public personality, that survivor doesn't have to have that story follow them for the rest of their life. Sometimes I've had survivors come forward and say, I want to tell my story. Fine enough. I've had some clients come forward and say, this was a part of my life that I want to deal with, close, and never think about again. Fine enough. Both sides are totally valid, equally excellent options to ensure that a survivor has control over how their story is told and how their life proceeds. If it becomes necessary to seek a publication ban or a sealing order, that's something that we can do. That's something that most criminal lawyers, the criminal crowns, are able to do. It's a conversation that you would have as a survivor with the legal service person to whom you're talking. And lastly, confidentiality agreements. So these don't necessarily need to happen in the context of a lawsuit or a criminal proceeding. These can happen whenever or wherever. For example, if you report internally, say to a union about sexual harassment or a sexual assault that you experienced, and that's as far as you as the survivor want to take it. You want internal accountability. Perhaps you want that person disciplined, moved, fired, and you achieve the outcome that you hoped for, or an equally valid and acceptable outcome. One of the things you can do is you can have a confidentiality agreement imposed on the situation. You can say, in this example, to the union rep, the perpetrator, and anyone else involved, that you would like to have a confidentiality agreement in place. This means that nobody outside the circle of individuals that dealt with the matter are permitted to speak about what happened. This can be a powerful tool if, again, the goal is to have it done and have that chapter closed. These are all options that are available to you as a survivor to ensure that your anonymity is protected. Now, I've saved what I would consider the largest topic for last, which is trial by media. All of the things that I've talked about so far, in my mind, they're issues that we can overcome with fairly discrete tools. Trial by media is a unique challenge for which we do have some tools, but for which we don't have as many tools as we would yet like. This is an ongoing discussion. So, as we all know, the media does love to report on these sorts of cases. For example, Hockey Canada, pastoral abuse. We're also thinking about the sexual abuse issues that have come out of the Canadian Armed Forces. These are all things that are forefront in the media right now. Our experience has been that when the media contacts us, and they do contact us to get comments sometimes, the tendency and the trend has been more towards respectful reporting. What this looks like is a reporter will contact our office and say, I want to write a story about such and such. I hear that such and such has happened. I found such and such a lawsuit or criminal proceeding. I want your comment on it, or I'd like your assistance writing about it. And so they'll talk to us about it. Sometimes they'll contact a client directly, and the client will ask us to assist them to interface with the media. In those cases, when a reporter has contacted us, our experience has been that reporters are trending towards protecting the privacy of the survivor, not outing the circumstances that specifically the survivor had to go through without the survivor's consent, and ensuring that the story is told from the perspective of the survivor. Now, of course, I can't speak for all media outlets, but this is a trend that we've been seeing. This is an especially important fact for survivors who are worried about coming forward because they're concerned that they will be scrutinized, outed, and have this follow them for the rest of their life. I want to reassure survivors that respectful reporting is happening. I think this is an especially important thing because we have seen people who have been vilified by the media. This is also a challenge that not many survivors do have to face. Survivors in high-profile cases, even extremely high-profile cases, they don't always have to speak to the media. They don't have to agree to speak to the media. And if there are tools that we've already engaged, such as initialization orders, publication bans, Jane Does, there can be all kinds of media attention. And at the end of the day, because you're legally protected from having anything published about you, your identity is protected, or they're not even able to find out who a survivor is in the first place. The media may not have the ability to publish anything about you. And so there are these protective tools that you can implement beforehand to ensure that if the media does come, you're protected. And also, it's important to note that the media can't access or publish certain parts of a case. For example, in a criminal proceeding, even if a criminal proceeding is considered a public matter, as the vast majority, in fact, all criminal proceedings are for the most part, if that criminal proceeding relates to certain specific restricted items, again, where the victim of the crime is a child, where there's been sexual violence, or where the person is especially vulnerable for whatever reason, a Crown or prosecutor can specifically seek a publication ban. And even if the media then is still present inside the courtroom, the media is prevented from publishing identifying information or information that would have somebody else able to identify the individual. Trial by media is still a unique issue faced by survivors of sexual assault and sexual abuse, though, specifically because of the issue I talked about on the first slide, which is credibility and memory issues. Something that is unique to survivors of especially sexual violence is even if the sexual violence goes on and on for months or years, the only witness and the only evidence is the individual who experienced the abuse. Clients have come to me and they've said, I'm afraid to say anything because I'm afraid I won't be believed because I don't have evidence. When a client says that to me, this is part of the reason I wanted to do this webinar. Your testimony as a survivor's testimony is evidence. It's evidence because you are testifying to the truth of what happened to you. When clients come to me and they say, I don't have evidence, I understand that what they mean is I don't have something else. I don't have some corroborating, supporting evidence. I don't have a second witness. I don't have forensic evidence. I don't have a video or a text message or something else that may support that what I'm saying is true. And I felt it critical to put it out there. A survivor's testimony can be enough. I have been successful in cases, multiple cases, where the only testimony that I have is a survivor's testimony. A survivor who gives testimony can be credible enough in their own favor to be believed by a judge. I want people to know that even in a digital age, even where the media may be saying things, even where individuals on Twitter and Facebook and YouTube and whatever may have their own opinions about the situation, may come up with whatever, may insist whatever, as hurtful and as destructive and as just uncomfortable as it is to have to look at all of those things or fear to look at all of those things as a survivor. At the end of the day, all that matters and all that should matter, and really all that matters is what a judge believes in the legal process, because that's where justice comes from in these cases, judge, adjudicator, whoever. You as a survivor can be your own best witness. You can be your own best advocate by simply coming forward and saying, this is what happened to me. With the right supports and the right tools, which can be available to you. There's lots of supports out there. Our office has a collection of them. There's lots of great websites out there. You can not only be your own best witness, you can actually convince somebody that the only testimony, the only evidence they need is your testimony. So I say to everybody, even though a trial by media is the scariest thing that I think most of my clients come forward to say that this is a concern they have, even if this is really something that continues to occur to prevent survivors from coming forward, it doesn't have to prevent survivors from getting justice. So I'd left some time for some Q&A at the end, Brenda. I'm not sure if this is something that was necessary, but I would be happy to take some questions at the end here. I feel like I've gone through a lot of the things that are unique to survivors in a digital age, especially internet harassment, internet bullying, trial by media. And there are tools that are available. If there's any other challenges that people would like me to discuss, I'd be happy to discuss them or take questions if there are any. If not, I've left my contact information here so that people can contact us and ask us if they have any questions. If there aren't any questions, I'm happy to talk about some more success stories instead.
Sure.
To give people some more hope.
Yeah, that would be great.
Okay. So we also, I should point out, one of the other concerns that we hear a lot is individuals who come to us, where again, we're civil justice lawyers. So what we do is we assist survivors who have been through various processes in seeking justice in the civil realm. Civil justice means you are advancing a lawsuit against somebody, some entity, some institution. Since the purpose of what we do is to help you seek justice against individuals, what we do is we often find individuals who come to us, survivors who come to us and say, I've already been through a criminal process. I've already been through an administrative process. And perhaps it was unsuccessful in those cases. Survivors will come to us and they say, I wasn't believed. The police didn't believe me. A criminal judge didn't believe me. The College of Teachers prosecutor didn't believe me. And in all of these processes, they may have come up empty. It's not unusual for us to hear that. In fact, I've had cases where somebody has come to us after a criminal proceeding has concluded, and that person has said, the perpetrator has walked. They were acquitted. They weren't convicted. And I'll take a look at the thing the judge has said or the decision that's been made. And in that case, a judge will say, I simply can't meet the burden of proof. I simply can't, which that means that I simply can't find that what happened beyond a reasonable doubt. That's not fatal to a civil case. Beyond a reasonable doubt is an exceptionally high evidentiary threshold. What this means is there has to be no other reasonable alternative, no other explanation, nothing that could make a judge believe that some other version of these events could have occurred. And that doesn't mean that a judge has to believe that a sexual assault occurred or some sexual abuse occurred. A judge has to be convinced that specifically the events that you insist occurred are exactly the things that occurred. So if you say, I was abused every Tuesday for 10 years, and a defense lawyer comes and says, but some Tuesdays you were on vacation, and you say, yes, that's right. That might be enough to get a judge to say, well, it wasn't every single Tuesday. You insisted it was every single Tuesday. It is an extraordinarily high bar to try to meet. So I don't want people to feel discouraged, especially survivors who have gone through the criminal process and not had the result that maybe they wanted. We have a different level of proof that's required. So instead of beyond a reasonable doubt in civil proceedings, we have to meet what's called balance of probabilities. Balance of probabilities takes the threshold from no other alternative down to effectively, is it reasonable that what you say happened? I had an example where a client of mine testified in court to a certain level of abuse, and then later on disclosed a higher level of abuse. This is not uncommon. As a client works through the emotions, dealing with the fact that they have PTSD, dealing with the fact that they've experienced a significant amount of sexual violence, sometimes that person isn't ready to face certain aspects of their abuse. So clients have come forward and disclosed this much abuse. And then as the process goes on, or as they work with therapists, as they become more comfortable, as they become more settled into a better and stronger support system, they're able to disclose more and more about their abuse. They're simply ready to face it. They're ready to process those feelings. I've had cases where that's happened. And the answer, we know now, science, psychology supports it. You face those issues when you're ready to face them as a survivor. The fact that you didn't disclose a certain level of abuse before simply says that you weren't able to face it. This is the same reason there's no limitation periods in civil proceedings anymore. There's no limitations in civil proceedings related to sexual abuse or sexual violence, specifically because the law has recognized that individuals who have experienced sexual violence come to being able to deal with it in their own time. And so the law recognizes that it takes as long as it takes for individuals who have experienced sexual violence to be able to face it. It's the same thing with memories. So don't want survivors to be discouraged about maybe not having a successful criminal or administrative proceeding at their backs when they come forward. There are still justice options available to them.
So yes, there's two questions, Ivanna. So the first question is, thank you for your time and information today. It has been helpful. Is it best to proceed through the criminal proceedings prior to filing a civil case?
Mm-hmm. So that depends on your specific situation. It can be helpful to have a criminal proceeding done first, but the reason I say it depends is because it depends on what you as the individual are able to tolerate. Not everyone is able to tolerate a criminal proceeding. Criminal proceedings are different than civil proceedings for obvious reasons, but also because in a criminal proceeding, an individual who has experienced this crime, they have less control over the process. And a criminal defense attorney, a lawyer, is permitted to ask questions relating to their rules, and they're allowed to cross-examine you in ways that maybe civil lawyers wouldn't cross-examine you in order to reach that resolution. So there are some cases where it makes sense that you do that first. I can say that having a criminal conviction can be helpful to a civil lawsuit, but as I just emphasized, not having a criminal conviction is not unhelpful. So it's not a death sentence if you choose to only proceed with a civil proceeding and don't go ahead with the criminal proceeding. But it depends on each specific circumstance, specifically because it depends on, like I said, not only what you can tolerate, but what you think what we civil lawyers and criminal lawyers and police think the likelihood of success is too. So it will depend on each case. But as a rule, we say to our clients, if you're interested in going through the criminal process, explore that option first. Since there's no limitations period, come to us once you've done that, or we can help you a little bit through that process as we go on.
Great. So the second question I have here is, can you please expand on timelines for things such as civil trials and court injunction orders and the other reliefs?
Sure. So orders for relief, especially things like injunctions, can be done fairly quickly. We have what's called urgent court hearings. You make a request for an urgent court hearing. Depending on the level of danger, threat to safety, or invasion of privacy that's occurring, you can be in court in a day or two, but more likely in a week. We are able to move quickly specifically because the courts have now created a process that recognizes that individuals are entitled to privacy protection to this level. Since the court has recognized that, for example, in the case that I've been referring to, we were able to fairly quickly get in front of a judge on an interim, which is called a temporary, or so to speak, intermediary basis, to get an order for a publication ban. And we were able to get a temporary order for initialization. So in that case, that meant that even if the media contacted my client, they didn't have to disclose their information. And even if the media did get their information somehow, there was an order already in place very quickly saying that the media was not allowed to publish any identifying information about the client to ensure that they were protected. Now, this can be really critical if an individual, like I said, doesn't want to have that out there, lives in fear of being attacked or harassed or having their safety affected, or they're afraid that their ability to move in a community is going to be affected. So it can be quite quick to get these. It can take longer to have posts taken down. Specifically, you have to contact certain social media companies directly. They can take some time to respond. I now, through experience and practice, have a much easier time contacting them because I have their contact information. And so I'm able to contact them quicker to say, you need to understand there's a privacy concern here, there's a safety concern here. And I say quicker. What I mean is, if you went through a regular non-urgent court process, it could take months to get these taken down. Obviously, having some information such as identifying information, private information, or accusations, allegations of falsehood or other slanderous things, they can be really detrimental, not only to an individual's mental health, like I've said, but to an individual's ability to carry out business, employment, regular life, interact with family members, move about in a community. So it's critical, not only from the individual's perspective on a mental health level, but also from the individual's perspective in a long-term life level to ensure that these get down quickly. So there are processes in place that can get them taken down in less than a few months, in maybe a few weeks, maybe a few days, depending on how quickly we're able to get in contact with the social media companies.
That's it for questions.
Okay.
Oh, wait, sorry, one more. Sorry, there's one more.
Okay.
For survivors of sexual violence, what are some first steps to access justice, especially for those who are unable to afford a lawyer?
Of course. A lot of provinces in Canada have implemented helplines. So these are helplines where a survivor of any sort of sexual violence, historic, contempt, any sort, can contact the helpline and say, I have experienced this sort of sexual violence in my life. That helpline will then direct you first to a lawyer who will give you, in most cases, 4 hours of free legal advice. I've been able to check, and I know for sure Ontario, Quebec, Saskatchewan, and Manitoba have these practices. I'm sure that other provinces do. I just haven't had an opportunity to look. Once you've had a chance to contact that lawyer for the first 4 hours of advice, sometimes you are also able to access, for example, free counseling services. In Ontario, there's a coalition of rape crisis centers and sexual assault service centers. So all across Ontario, there are these service centers that are specifically geared towards assisting survivors of sexual violence. They can also support you in a mental health way, but if we're talking about access to justice specifically, they do know how to help you go through the justice process, specifically through the criminal justice process. They can offer support programs. There's a great program out of Waterloo Region, for example, the Waterloo Region Women's Violence Support Center. They offer a court assistance worker program. So what that is you contact them and you say, I have to go through a criminal trial. They'll send somebody with you as a support person to be there with you consistently as you go through that process. Having that level of consistent support, if you're going through something this difficult, having somebody that's specifically there just to take care of you can be a huge difference and can make the difference in ensuring a survivor can actually get through the process, has been my experience. So that would be one of the first steps that I would recommend. Civil lawyers can also give free consultations in some cases. So you may be able to contact a civil lawyer to say, this is what's happened, what are my options? And in most cases, if you report to the police will take a complaint and they'll investigate it. So one of the first steps, if you're interested in going through the criminal justice process, is reporting to the police and letting the police decide, is that something that they can investigate? Now, reporting to the police can do a lot of the work, have a lot of the work done for you. It'll mean that the police will take care of investigating into the individual. They may even collect witness statements. They may collect corroborating evidence. Sometimes they investigate and sometimes they don't. So if that's a process that is something of interest to a survivor, that's something that a survivor can also look at as doing as a first step.
Okay, we have one other question in here.
Okay.
If reporting to the police, can a complainant bring a support person?
Yes, so they can, but my understanding is when they go into the actual interview, because they do have to give a statement to the police and carry out an interview with the police. In the interview room, my understanding is a support person is still not permitted, but you are allowed to bring someone with you to the police station. And if they've now permitted the support person to be in the room while you give the testimony, then, or while you give your statement, then all the better. So I do, if somebody would like to have a support person with them when they go to the police, I encourage them to go with a support person for sure.
Great. Okay, I actually think that might be the end of questions, but certainly, as you said, encourage anyone to reach out should they have any additional questions.
Okay.
Yeah.
Thank you very much.